14038.
Okay, we are on record and broadcasting this afternoon on YouTube for the seventh review for both parents and the guardian, as well as a trial and a termination petition. May I have the names of our participants, please?
Carson Howard, lawyer, guardian ad litem.
Nastasia Thomas, counsel for the department.
Emma Copus, foster care specialist with Lenawee County DHS.
Michael Brooks, I am the court-appointed attorney for the father, Brad James Rebatis. If that's wrong, I apologize to the father.
Okay, sir, I think I see you trying to speak. You'll have to unmute. Could you give us your name for the record, please?
Can you hear me?
Yes.
My name is Brian Rublitis, father of Decimate.
Could you pronounce your last name again, sir?
Rublitis?
Rublitis.
Yeah.
Karen and Infant, attorney for mother, Miss Roush. Cassandra Roush, Decimate's mother.
Thank you.
Your Honor, I'm so sorry. I'm so sorry to interrupt. I just wanted to inform the court that Miss Spencer is on Zoom as well.
Who's Miss Spencer?
The court-appointed attorney for the minor.
We have Ariel Berger, who's about to introduce herself.
I'm the attorney for grandfather Gregory Roche. I believe Miss Spencer is the attorney for minor child.
All right, she is not here.
She said that she's in a breakout room, Your Honor.
Oh, really? They're not open, so if she is, it's not in my courtroom. If somebody's in communication with her, tell her to log out and log back in. Try it again. Make sure she's got the right Zoom room number, please.
Okay.
That's not usually like her. She's usually right on it, so hopefully it's just a glitch. I do want to say we do have the juvenile also logged in. I went ahead and terminated the camera feed because we're on YouTube this afternoon. She is present with us from the place where she's currently residing under Stephanie Pardo Juarez. So we appreciate you joining us this afternoon. All right, so as we await the arrival of the attorney for the juvenile, are there any preliminary issues before we get into the review and combined termination request?
Yes, Your Honor. We received the summons, I believe, on July 31st. The department, on my fault, did not have those petitions filed in time to get it served with the required 14 days notice. So I know that we would need to be looking at an adjournment on the termination component. And I believe that we would also need the preliminary and pretrial hearings for that as well.
Okay, and here's Ms. Stang. Ms. Stang, would you like to introduce yourself?
Alexis Stang on behalf of DJ.
Thank you. Okay, so the only thing really that you asked is introductions, and Ms. Thomas informing us that she's requesting an adjournment to allow for proper service on the termination petition, especially as it relates to Ms. Resch. And then the petition newly, I think, indicates Mr. Rublitis as a respondent, and so we'll need to conduct pretrial preliminary hearing on his aspect of the case. Okay, any comment on that on behalf of the parents?
No, we have no objection to the adjournment on the termination portion.
No, neither do we.
Okay, all right. Do you wish to have the pretrial conducted today, Mr. Brooks, or would you like me to also find a different day for that?
No, that'll be fine. I'd like to hear what's going on. It says this case dates from 2014, but I have no recollection of it. As far as I know, this is the first time I've been in this case.
Well, we're here on petition 2, so this has not been pending since 2014. It's a relatively newer petition, at least newer than that. And your client has been newly named as a respondent parent. So he's a bit late to the proceedings, which may also explain why you haven't been here before this.
I really don't have anything here saying what it is he has or has not done in any of this petition.
Okay.
So I'd like to hear what the preliminary allegations are. And I'd like to see, all I see is something here that says Mr. Roblitis is here because they're gonna terminate his parental rights. That's all I got.
Okay, before we get into the pretrial, I do want to note too that our guardian, Mr. Gregory Resch, is also here today. So welcome. All right, as it relates to the pretrial, Mr. Brooks obviously has a copy of the petition, which is great. Deputy, should you swear in Mr. Rublitis, and let's make sure he has a copy too. Join us, please.
Thank you, Your Honor. Sir, can you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yep.
Okay, Mr. Rublitis, do you have a copy of the supplemental petition? It was filed in court July 31st, 2025. You should see a stamp on the front that reflects that date. Do you have a copy of this document?
Yes, I do.
All right, very good. Do you have any reason to believe that you or any member of your family is a member or eligible for membership in any Native American tribe or band?
I'm not sure.
Very good. Has anyone ever asked you that question?
No.
So do you know if you have any family members that might have been a member of any of the tribes, like the Sioux tribe or the Cherokee tribe, or any reason to believe that anybody would have been part of that?
No, I don't think so.
Okay, all right. Well, if you come to any information that might point you otherwise, you're going to need to let your attorney and the caseworker know as soon as possible. Any question on that?
Yeah, I didn't know I had an attorney.
You do.
It's me.
Okay.
Yes, now that you've been listed as a respondent parent, you are entitled to an attorney, which is why Mr. Brooks is here for you. You can retain your own attorney if you wish, but
No, that's fine.
your parental rights are a matter of constitutional rights. So when there's a request to terminate your parental rights, as there is here, you're entitled to an attorney for that process, and that's why Mr. Brooks is here. Any questions?
Okay. No, ma'am.
Very good. He'll be here for you for this and all subsequent hearings, unless you find a different attorney that you might want to hire on your own. Okay?
Okay.
Right. So
I don't
there's-
want to lay in the weeds here, Your Honor, but I've just looked at this again, and there's absolutely no factual allegations against this man. Nothing.
Okay, Mr. Brooks, you're just a little bit premature on that point. I've got a couple more preliminary questions I need to go through with your client.
Excuse me.
Thank you. All right, Mr. Rublitis, obviously you've been here for a few hearings before this, but are you aware of any other cases that might concern your child? Child support, guardianship, I know we have a couple of those.
No, I just want to know what's going on. What happened with I don't remember his name. Cassandra's other Miracle's dad. I don't know what's going on with that. I knew something was going on before, but I don't know what's going on now.
Well, I don't know who Miracle is, but we're here today on the child whose initials are OJ, okay?
Okay.
So that's your child, right? Your legal child?
Yeah.
All right. So the petition, it has a couple of pages on the front that are a form, and then it's a typed up document entitled Addendum to Supplemental Petition, and that's got a bunch of numbers too, and there's 5 pages of that. You're entitled to have this read on the record in its entirety. Would you like me to read it, or would you like to waive that right?
You can read it.
I'm sorry?
You can read it.
Okay, so beginning on the first page, the supplemental petition that contains a request to terminate your parental rights indicates the case number, petition number 2, the name, date of birth, and current address for you. It also contains the name, date of birth, and place of birth of your child. It lists the mother of the child, her date of birth, and address and phone number. On the second page, The relevant paragraphs begin at 3B. There is one or more pending or resolved cases within the jurisdiction of the Family Division of the Circuit Court involving the family or family members of the persons who are the subject of the petition. I have separately filed a completed confidential case inventory, MC21, listing those cases. Paragraph 4 says the named child comes within the provisions of MCL 712A.2B1 through 6 as follows. The boxes that are checked are 2. The first one is the parent or other person legally responsible for the care and maintenance of the child when able to do so, neglected or refused to provide proper or necessary support, education, medical, surgical, or other care necessary for the child's health or morals, or he has subjected the children to a substantial risk of harm to his or her mental well-being, or he has abandoned the children without proper custody or guardianship. The second box indicates a home or environment by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of the parent, guardian, non-parent, adult, or other custodian is an unfit place for the child to live in. Then we move to paragraph 5. The reasons why it is contradictory to the welfare of the child for the child to remain in the home are, please see the attached addenda as to why it is contrary for the subject minor to be in either parent's care and custody at this time. Paragraph 6 is checked. The reasonable efforts made to prevent the removal of the child include, please see the attached addenda noting the reasonable efforts to prevent removal of the subject minor as it relates to each parent. Paragraph 7, the specific allegations are, please see the 2 addenda attached to this JC04B. Given the respondents being differently situated, each addenda contains information specific to the respective parent noted in the heading, and each is signed by different caseworkers. Paragraph 8, I request the court to authorize the petition, take jurisdiction over the child, and terminate the parental rights of the father, as well as terminate the parental rights of the mother to the child concerned by the petition, which is again OJ. It's signed by Eva Kopis and Nikki Jones, both with permission, and of course the attorney for the department, Ms. Nastasia Thomas. Next is the confidential case inventory that references the other cases that were filed and did concern your child. That includes, of course, a delinquency case file number, the support case number between yourself and the mother and the child, and the guardianship case file number that concerns Mr. Gregory Resch and Cassandra Resch. All right, I'm not going to read to you the Cassandra Resch addendum because it doesn't really relate to you, and you have your own separate set of rights as it relates to these proceedings. So we're going to your own separate addenda. And here it is. Addendum to supplement the petition for removal, jurisdiction, and termination of parental rights at initial disposition as to respondent Bradley James Rublitis. Jurisdiction and venue. 1. Petitioner restates and incorporates by reference the jurisdiction and venue allegations contained in the addendum to the supplemental petition to terminate parental rights of the respondent mother, which is filed simultaneously with this addendum. Factual allegations: Bradley James Rublitis. Neglect, physical, educational, medical, emotional, substantial risk of harm to mental well-being, abandonment and unfit home environment, neglect. 2. CPS complaint. On June 2nd, 2025, CPS received a complaint generally alleging physical neglect of OJ. Bradley James Rublitis was the listed perpetrator. 3. During the investigation, OJ was forensically interviewed, and when asked about her father, well, they're referring to the child as DJ. So I'm just going to read what's in the petition. During the investigation, DJ was forensically interviewed, and when asked about her father, DJ redirected the conversation back to her mother and grandfather. She did not provide any information or disclosures about her father. 4. Bradley was aware of DJ's removal from her respondent mother. A. 10/4/23. Putative father received notice of the hearing. B. 10/20/23. Bradley appeared, named legal father, noted there was involvement since she was 2 years old, and was aware of the conditions of the child's living environment when she was removed from respondent mother in 2014. C. 1/10/24. Bradley appeared. DJ was bothered by him being on Zoom. Referred to her sister's dad, Clarence, as her dad. The court order noted, quote, the agency has had minimal contact with non-respondent father this reporting period. He moved and took a new job. He has little contact with O during this reporting period, end quote. D. 9/5/24. Bradley was not in communication with FCW for a few months. reported he would have legal counsel in the spring of 2024. There was some contact with Bradley and DJ through the facility. Bradley was noted present at the hearing. E, 11/22/24. Court order noted Bradley present. F, 2/4/2025. Court order noted the father Bradley has abandoned the child. G, 5/19/25. The court order noted the father Bradley did not appear. Paragraph 5. DJ has accused Bradley of sexual abuse on 2 separate occasions, although neither disclosure was substantiated due to DJ's intellectual impairment and the lack of additional information. 6. Bradley appears to lack insight into his daughter's impairments, as evidenced in conversations with him that he was not aware of his daughter's needs. 7. Following DNA testing, Bradley was granted parenting time with the child and has failed to participate in any interaction with the child. 8. Bradley has not offered any financial support or made any attempts to provide for DJ's daily needs. 9. Bradley failed to address the issues that led to the child's initial removal, despite a reasonable opportunity to do so. 10. Bradley's absence appears intentional, and there were no efforts made by him to reestablish a relationship with the child. 11. Bradley has not attempted to contact DJ for more than 91 days or make a genuine effort to create a stable environment for her. 12. Bradley has not attempted to establish custody of DJ since becoming her legal father. 13. Given Bradley's abandonment of DJ, it does not seem that he would be able to provide her with a proper home environment. Best interest factors. 14. Deputy Ames, would you mind getting me a glass of water?
I will, Your Honor.
Ms. Thomas has done a nice job of articulating a number of pages of reasons for the filing of the petition. Paragraph 14. The child's need for permanency, stability, and finality. The child's need for permanency, stability, and finality are imperative to her growth and development. The child caring institution is the most appropriate setting to meet the child's needs at this time. The minor is 15 years old and is in need of constancy to thrive. She has behavioral, cognitive delinquency, and mental health issues that require ongoing attentiveness and a caregiver who is devoted to constant monitoring and supervision. 15. The child's bond to the parents. Given the lapse in time since Bradley has been a part of the child's life, it is unlikely that the child looks to him as a primary attachment figure. 16. The parent's parenting ability. Bradley has not demonstrated an ability to parent this child, as he has not been an active parent in her life. Voluntary absence without valid cause weighed heavily against the parent, reflecting a lack of commitment to the child's welfare. 17. The advantages of a foster home over the parent's home. The child is placed in a home for children with developmental disabilities and cognitive impairments, and she meets those criteria by having an FSIQ of 57. This placement will need to be focused on her needs around the clock, and she currently receives a one-on-one in the residential treatment setting. The child has significant needs and requires a caregiver that is actively involved in her treatment regimen. Thank you.
Welcome.
Given Bradley's absence from this case, it is unclear what his living arrangement is or what he could offer him. 18. The parent's compliance with the case. Bradley was not a respondent in the prior removal, so does not have a case service plan. However, he has been informed of the child's multiple needs, given contact information for the facility, and has failed to engage with the child's caregiver in an effort to understand her continuing needs. 19. The parent's visitation history with the child. Bradley was deemed to be the legal father during a preliminary hearing on October 20th, 2023, following a DNA testing completed on August 14th, 2023, and granted supervised parenting time. According to the residential treatment facility, Bradley has had the following contacts with the child by telephone since her entry into foster care. 10/10/2024, 2 minutes. 10/20/2024, 2 minutes. And 4/25/25, no answer. 20. The child's well-being while in care. The child is in residential treatment where she continues to struggle with healthy boundaries, peer interactions, personal hygiene, and rule expectations. Bradley has not demonstrated an ability to appropriately meet DJ's needs even prior to placement into foster care. 21. Whether the child is in relative placement. The child was previously in a legal guardianship with maternal grandfather Gregory Howard Resch Jr. However, he was no longer able to care for her due to her behaviors. The The child was determined to be incapacitated and was unable to be detained on juvenile delinquency charges. I guess we're looking for incompetent on that one. The guardian was unable to adequately address the child's behaviors and at times had been unwilling to do so, evidenced by his refusal to pick her up from detention from August 2023 through September 2023. Fictive kin and relatives have been explored, all of whom have declined to care for the minor child. 22. The possibility of adoption. The current placement is willing to assist in adoptive efforts to secure a family that is able to meet the child's ongoing needs. 23. Ethnic and cultural considerations. The Child Caring Institute is able to meet the child's ethnic and cultural practices. Bradley denied any ethnic or cultural considerations. 24. The child's relationship with extended relatives. The child does not have contact with parental relatives. She has a strong bond with her maternal grandfather, Gregory Howard Resch Jr. Mr. Resch no longer wishes to be reunified with DJ and agrees with the goal of adoption. He intends to continue visiting the child at her placement and facilitating siblings between her and her younger sister. 25. The length of time the child has been in foster care. The child has been in foster care since October 4th, 2023. She has not resided in her mother's care since before February 25th, 2013. Prior to entering care, the child's maternal grandfather, Gregory Resch, had legal guardianship of her. She has never lived with Bradley. 26. The child's wishes. The child does not wish for her mother's parental rights to be terminated. Excuse me again. When she was approached about her father during the investigation, she changed the subject. She wishes to be reunited with family. Her cognitive and intellectual impairments prevent her from understanding her mother's inability to appropriately provide for her care. 27. The opinion of experts, including LGAL, therapists, caseworkers, psychologists, etc. The department, Wedgwood Christian Services, and the LGAL Carson Howitt are in support of termination of the parent's parental rights. 28. Whether the child has special needs. The child has cognitive and intellectual impairments with an IQ between 53 and 57, which greatly impacts her daily functioning. Statutory citations. 29. Required petition. This is a required petition for jurisdiction for policy for abandonment, which is when a person responsible willfully deserts or surrenders a child without making adequate arrangements for the child's basic needs or the continuing care of the child. See also MCL 722.6381AI. 30. Statutory grounds for adjudication. Based on the above stated allegations, jurisdiction is proper under the following subsections of MCL 712A.2b. The child is under the age of 18 and the child's parent, when able to do so, neglects or refuses to provide proper or necessary support, education, medical, surgical, or other care necessary for the child's health or morals, who is subject to a substantial risk of harm to her mental well-being, who is abandoned by her parent, and 2, the child's home or environment with Bradley, by reason of neglect on the part of a parent, is an unfit place for the juvenile to live in. 31. Statutory grounds for removal. Based on the above stated allegations and pursuant to the following subsection of MCL 712A.13A9, removal of the child from Bradley's care and custody is necessary, as all of the following factors are true. A. Custody of the child with the parent presents a substantial risk of harm to the child's life, physical health, or mental well-being. B. No provision of service or other arrangement except removal of the child is reasonably available to adequately safeguard the child from risk as described in subdivision A. C. Continuing the child's residence in the home is contrary to the child's welfare. D. Consistent with the circumstances, reasonable efforts were made to prevent or eliminate the need for removal of the child. E. Conditions of the child away from the parent are adequate to safeguard the child's health and welfare. 32. Petition to terminate parental rights at initial disposition. This petition is submitted under the mandate of MCL 722.638 subsection 2. 33. Statutory grounds for termination of parental rights. The statutory grounds for termination of parental rights is authorized under MCL 712A.19.3 include B3 include A. The child has been deserted. As the child's parent has deserted the child for 91 or more days and has not sought custody of the child during that period. G, the parent, although in the court's discretion, financially able to do so, fails to provide proper care or custody for the child, and there is no reasonable expectation that the parent will be able to provide proper care and custody with any reasonable time considering the child's age. J, there is a reasonable likelihood based on the conduct or capacity of the child's parent that the child will be harmed if he or she is returned to the home of the parent. 34, best interest factors, as required by MCL 712A.19b5 and defined by case law. It is in the child's best interest to terminate the parental rights of Bradley James Rublitis, which is detailed above. Relief requested. 1, authorize this supplemental petition for removal, jurisdiction, and termination of parental rights and initial disposition as to respondent father Bradley James Rublitis. 2, issue an order maintaining the child's placement with the department. 3, make a judicial determination that reasonable efforts to prevent removal and to reunify the child and respondent father are not required based on abandonment. 4, continue the suspension of parenting time pursuant to MCL 712A.19b4. 5, set this matter for an adjudication, trial, and termination hearing. 6, take jurisdiction over the child pursuant to MCL 712A.2b1 and 2. 7, terminate the parental rights of the above named parent pursuant to 712A.19b3, 4, and 5. And 8, grant any other relief this court deems adequate and appropriate under the circumstances. Respectfully submitted, July 30th, 2025, by Anastasia Thomas and Nikki Jones from the Department of Health and Human Services in Lenawee.
All right.
Okay, so there's the petition with the allegations that specifically pertain to you, Mr. Rublitis. Now, it doesn't sound like you've had a chance to talk to your attorney about how you may wish to proceed, because you have the right to admit to the allegations in the petition with an explanation. You have the right to deny them, and you have the right to a hearing wherein the department has to prove. Mr. Rublitis, can you hear me?
Yeah.
Okay, because I'm explaining your rights to you, and I need you to listen carefully so you know what your options are. Can you give me a few more minutes to just listen, please?
My phone's about to. Good.
Okay, Mr. Rublitis, if you're not able to maintain a connection on Zoom or by phone, then you would need to be here in person. But the long and short of it is you have a right to a trial on this. So I can either set this for trial or you can admit to these allegations. But you probably need to talk to your attorney about it before we go any further.
Yes.
Okay, I'm going to take that as a yes. I want to talk to my attorney, and Mr. Brooks concurs. So I believe for purposes of today, we've gone over everything except your specific trial rights. And given the electronic limitations you have at the moment, I'm going to give you your next court date. I'm just going to set this for a pretrial, Mr. Brooks, if that's okay with you.
Yes, it is.
And then I'll go over your client's rights with him next time you come back, and I'll trust you. And Mr. Rublitis, you'll need to get a hold of your attorney to speak with him about this if you wish to before you come back. Understood?
Yeah, I need his number.
Okay, we'll do that in just a minute. Right now, I'm going to give you your next court date.
Okay.
Okay. Can you come back next week, or do you need more time than that?
Next week, I'll take the whole day off so I can focus on this.
Okay. Well, I have some time on Thursday, the 21st.
Thursday the 21st.
At 9:30.
21st, 9:30.
Your Honor,
Okay.
do you need me present for that?
Well, I don't think so.
Perfect.
Because you represent the guardian.
Yes.
This is just on dad, so I don't think you would need to be present.
Perfect. Thank you.
Okay, Mr. Brooks and Mr. Rublitis, you're due back here August 21st at 9:30 in the morning to determine how you want to proceed on this petition. Any questions?
None.
Okay. All right, if you need to excuse yourself from the meeting, then so be it. We'll see you Thursday, August 21st at 9:30.
Okay, so how do I get his number?
Oh, hang on one second.